Welcome to The Safe Space, a quarterly series by LASSA Texas that provides information and resources to survivors of sexual assault. My name is Ashley Norris, and I'm the Digital Marketing Manager for Lone Star Legal Aid. Today, I'm joined by Brittany Hightower, our Supervising Attorney of Program-Wide Units, and Staff Attorney Becky Stevenson to provide information regarding Title IX and campus safety. Lone Star Legal Aid helps eligible clients with their civil legal issues across 72 counties in East Texas and 4 counties in Southwest Arkansas. The organization is one of 9 grantees of the LASSA grant through the Texas Access to Justice Foundation. Legal Aid for Survivors of Sexual Assault, LASSA, is a statewide collaborative network of legal service organizations working to ensure survivors have access to critical civil legal services throughout Texas. The network provides free legal education, advice, representation, and other resources. You can learn more about LASSA by visiting www.lassatexas.org. But before we begin, this presentation is intended to serve as legal information and does not replace legal advice. Contact Lone Star Legal Aid at 1-800-733-8394 or go to www.lonestarlegal.org. for more information on legal assistance. Lone Star Legal Aid does not discriminate on the basis of race, color, religion, gender, gender expression, sexual orientation, age, national origin, ancestry, disability, marital status, or military status in any of its activities or operations. Brittany Hightower is a supervising attorney over program-wide units at Lone Star Legal Aid. Previously, she was a senior staff attorney at the Individual Safety Unit at LASSA, where she represented survivors of sexual abuse in protective orders, divorces, custody, evictions, Title IX complaints, and more. Prior to joining LSLA, Brittany worked as an attorney for the Office of the Attorney General of Texas, the Williamson County Attorney's Office, and Texas Advocacy Project. She was named one of Texas Lawyers' 2016 Lawyers on the Rise. Brittany earned her JD from Georgetown University and her BA summa cum laude from Texas State University. Becky Stevenson is a staff attorney at Lone Star Legal Aid in the Individual Safety Unit, where she represents survivors of sexual abuse in protective orders, divorces, custody, evictions, Title IX complaints, and more. Becky is in her second year at LSLA. Prior to joining, she worked for other nonprofits addressing issues with refugee survivors and clerked for a federal judge. She has been advocating for survivors of sexual assault since 2013 and is especially passionate about campus safety. Becky earned her JD from Notre Dame and her BA from Baylor University. Let's start with our first question. Becky, what is Title IX?
Title IX is part of the Education Amendments as part of the Civil Rights Act. And its aim is to ensure equal access to education, regardless of gender. So basically, you have a right to an education without gender-based violence. And sexual assault, sexual harassment is a form of gender-based violence and would impede somebody's ability to seek an education in an equal way.
Brittany, what kind of behavior does Title IX cover?
So a little bit of what Becky touched on. It covers any form of gender discrimination on campus, and that can take any different kinds. That can be what people classically thought of in back in the 80s when they started making movies about this in the workplace, where, you know, a supervisor is making sexual comments to a subordinate employee or conditioning their performance reviews or conditioning raises on whether they perform sexual favors. That's typically what people think of as sex discrimination, but Title IX's definition is actually much, much broader than that. It includes all types of sexual misconduct from one student to another, from faculty to students. And so, but it's kind of limited to place, but it can include sexual assault, dating violence, sexual harassment, or just simply treating somebody differently on the basis of their gender.
Becky, which schools does this apply to?
So Title IX applies to every school that receives any kind of federal funding. So Congress has conditioned its funding for schools on compliance with Title IX. So this applies, and so in non-lawyer speak, what does that mean? Basically, any school that gets LASSA, or pretty much every public school, charter schools, trade schools, even require Title IX compliance. And it's almost impossible for a school to get out of this, for especially a college to get out of this, unless you are Hillsdale, which is the one exception, pretty much. And Hillsdale notably does not receive any federal funding. They are grassroots in that way. So they're the only school that doesn't require a Title IX office, or, certain investigations to the letter. But everyone else, every other college, community colleges, public schools, charter schools, even private colleges require compliance with Title IX.
And just one thing too, Becky touched on this too, but the FAFSA, that means even if they're receiving any amount of federally backed student loans, it's the money that the student is receiving the money, but then the school is going to receive that federally backed student loan, which means they're receiving federal funds, and so they have to comply. And that's why Hillsdale doesn't have to comply, because they don't accept federal student loans.
Okay. Brittany, these next two questions are for you. Are there differences between colleges and K-12 schools?
There are differences between college and K-12 schools. Not necessarily in the gender discrimination that's covered, but in how the schools are required to respond to them. The regulations include very strict procedures that schools need to set up if they are post-secondary, which includes having a live hearing where somebody's asking cross-examination questions of both the what's the word that they use in the regulations? The complainant, what we would refer to as the victim or the survivor, and then the person who's accused, the respondent in the case. And so there needs to be a live hearing. There's a whole procedure that has to take place. But realistically, we don't want to be doing a live hearing with cross-examination questions to 7, 8-year-olds. So when it comes to K-12 schools, the schools themselves have a lot of leeway to structure their procedures in the way that they seem best for their school, or the way that seems most appropriate for the students, given their age, their needs, etc. But in practice, the way that works out is that they just kind of ad hoc deal with it as the complaints come in. So there's a lot more structure to the college procedure, but it has a lot less flexibility. In the K-12 schools, there's a lot more flexibility about how you approach this, given the individual needs of each survivor. But a lot of times you run into a situation where the people who are in charge don't necessarily know what they're doing, and aren't as informed as they should be about what would be best to handle it.
So if a college student is sexually assaulted on campus, what should they know?
So some of the most important things to know are, first and foremost, there are resources, even if you don't want to report it. For a lot of survivors of sexual assault, specifically on campus, it's a much more independent environment. And so they may feel like they still have to complete their schoolwork on time. They still have to show up and go to a test the next day. And that's just really, really hard to do when you're dealing with all the trauma, independent of seeking medical care or making a criminal complaint or the other things. Just psychologically processing what happened to you can make it really, really hard to still be a good student and stay as focused as you'd like to be. So there's all sorts of resources that you can request called supportive measures, where the school can reschedule tests for you. The Title IX office can communicate with professors and explain you might need some more time for an assignment. Sometimes professors have the ability to go ahead and give you a grade based on the work you've completed. We've even been able to work with Title IX office to get someone's student housing extended, even though they weren't able to continue participating in their athletic program that was directly tied to their housing. So there's all sorts of things we can do to ensure that student is still receiving their education, because that's the baseline point of Title IX, without them having to go through the formal complaint process. If they want to make a formal complaint, there's no obligation, but if they tell certain people on campus, if certain people, and each school gets to designate who is a required reporter. that person may have to report it to the Title IX office, and that may trigger an investigation whether the survivor wants one or not. And then lastly, if the survivor does want to have an investigation, they have the right to go to the Title IX office, make a formal complaint, and initiate that investigation process.
And Becky, these next two questions are for you. What if a sexual assault happens on a K-12 school campus?
Yeah, so first of all, Title IX covers activity not just between like students, but also teachers and students. And so the next question we would ask is, was this conduct an adult, done by an adult, or was it done by another student? If it was done by an adult, there's an extra thing that needs to happen, and that is that every adult working at that school is a mandatory reporter for child sexual abuse. And that's for law enforcement. But for Title IX purposes, so we see this a lot, actually, in LASSA. We handle a lot of these cases where, 8-year-olds inappropriately touch each other. Title IX does cover that. Parents have a right to know what's going on with their kids and the procedures that they can place. Every school district is required to have a Title IX coordinator and investigate upon receiving complaints. But usually, actually, schools don't go through the Title IX route, or like students don't go through the Title IX route in K-12 schools. So they are supposed to be made aware of their rights. They don't have a live hearing like they do in colleges, partly because you're usually not, the student is usually not financially on the hook for that education, and they're not legally an adult. That said, the most common thing that happens with schools K through 12 is school stay away agreements. And so those are not necessarily admissions of guilt on the part of the student who committed the act, the misconduct, but they do keep the students away from each other. So they separate them in classrooms. They, agree there. It's an agreement in writing that that both students will be separated and avoid each other or face other consequences.
And what is the process for reporting misconduct to the school?
Yeah, so with Title IX, again, there are two kind of routes for K through 12 schools. One of which is Title IX, and that's less, even though schools are required to be compliant with Title IX and that, your school district will have a Title IX office, that is far less exercised than the school complaint process. I'm going to explain both. So to report a Title IX complaint, you would reach out directly to the Title IX office for the school district. Every school website, every school website is required to have that open and apparent on their website, a place explaining identifying who the Title IX coordinator is, what their procedures are, and how to contact them. So if you were to file a complaint, if you were a parent trying to file a complaint on behalf of your child, that's what you would do for Title IX. Informally, there's a process that you go through with the school, and that could be done alongside Title IX or instead of Title IX. So if you have a problem, but this is kind of after the school stay away agreement. So if you have a complaint about how the school has responded either to your child's sexual misconduct, like that they've been a victim of, or your child has been accused of this misconduct, and you have an issue with the way the school has been handling it, and you don't think that they've done it to the letter, then you can file a complaint with the principal. And then there are a couple different levels. Sometimes it depends on like what school it is. But the next level is, superintendent and school, and then up to school board. And so, but these are kind of like levels of appeal, if the school has failed to respond in a way.
And Brittany, what happens after the report is made?
So Becky already covered what's going to happen after a report is made in the K-12 context. So I'm going to talk a little bit about what happens on colleges. So once a formal Title IX complaint has been made to the Title IX office, the Title IX coordinator is going to appoint an investigator to conduct a thorough investigation. And that's usually going to involve talking to the complainant, what we would refer to as the survivor, and then also talking to the respondent. Nobody's obligated to participate, and there's no subpoenaing or detaining somebody like you would in a criminal context. So it's really just about who's willing to cooperate and provide information to the investigator. Once the investigator completes their investigation, then they typically submit some sort of a report. They're usually not the ones to make specific findings or specific determinations. They just identify what is undisputed. For example, maybe both the complainant and the respondent were at the same party. That's undisputed. Everybody agrees that happened. But everything else, people disagree on. And then once that investigation is complete, then there is a live hearing scheduled. There needs to be somebody who's going to conduct the live hearing that should not be the investigator and should not be the Title IX coordinator. But often one or both of those people will still be present for the hearing just to oversee how it's conducted. Then the hearing officer will ask questions of the complainant, ask questions of the respondent. Both parties are able to ask questions of each other or other witnesses that are available, called cross-examination questions, but they can't do it directly. So they have to have an advisor. That advisor can be an attorney, but it's not required to be. And if the party doesn't choose their own advisor, the school is required to appoint one for them that will ask the cross-examination questions of the other witnesses on the other party. And then once the hearing is concluded, then the hearing officer will make a final determination. And then the regulations require that the school provide a procedure for appealing that final determination. If the one or other student is not in agreement with it and feels that they didn't follow the regulations and the school specific policies on that. At any point, the regulations do offer either student to propose an alternative resolution. Different schools call these different things, but really it's a way to resolve this without going through the whole formal Title IX complaint process with the live hearing. And sometimes that can look like requesting a written apology, a mediated face-to-face conversation, or just withdrawing a Title IX complaint, or many other variations. Once there's a final determination, if the respondent is found to be responsible for that conduct, then the school has wide discretion to impose any sort of disciplinary measures on them. However, if the student is found not responsible, then it's effectively like an acquittal in a criminal case where everybody just goes about their business and nothing happens to the respondent.
Becky, what kinds of protections are available for survivors?
So as Brittany mentioned earlier, regardless of whether you actually file a complaint or, want somebody punished, you do have a right to an accommodation, specifically like a reasonable accommodation from your institution. So those can look like anything from extra time on a test to having your schedule changed so that you don't have to see your rapist, or, even, as Brittany mentioned, like having only the grades that led up to the point of the assault considered, or even like changing things to pass fail after the like pass fail deadline has passed, because a D can really be bad. It can really hurt your transcript, but a pass just, it doesn't affect it as much. So you have a right to feel safe on campus. You have a right to an education free of gender-based violence or gender-based discrimination. And so there are also ways in which you can be afforded protection from retaliation. I might let Brittany talk a little bit more about that, because it's more common on college campuses and graduate school settings. But in short, there can be consequences for institutions and like organizations when they retaliate against a student who decides to make a Title IX report. So you should be able to report, not only should you be able to have the space you need to recover from this, but you also have the right to not be retaliated against because you said something.
Yeah, I can piggyback on that for college campuses. Retaliation often is treated more seriously than the underlying conduct itself. And I kind of understand why, but I also take issue with that. But that's a whole other discussion. So when it comes to retaliation, the regulations impose a duty on the schools to ensure that the process is protected. So therefore, there are and should be very harsh consequences for anyone who retaliates against anyone for participating in the process. Rarely is it ever anybody's retaliating against the respondent, but bigger concerns are somebody retaliating against the person who's making the complaint or the survivor, or especially any witnesses. And so that can look like making intimidating threats. That can look like social consequences, for example, punishing somebody within a fraternity or sorority for participating in the process, anything like that. So schools take that very seriously.
Brittany, what are the potential consequences for perpetrators?
So there's a wide variety of possible consequences. The regulations give schools a lot of discretion to determine not only what the consequences could be, but also what they should be after a finding of responsibility. And they run the gamut. They can be as extreme as expulsion, but I've only seen that happen in pretty egregious cases where there's a lot of evidence, all the way down to, I had one case in particular where he was found responsible for the sexual misconduct, and his only punishment or consequence, I guess, was that he had to retake his Title IX training, even though he was in the middle of Title IX training when he committed the misconduct. But there's really no way to appeal that. Schools, again, just have the discretion to make that determination. There is one much more extreme consequence that they can do up front called emergency removal. That needs to show an individualized investigation into that particular person and incident. And it has to show that that person poses an immediate threat to the university or the school itself, not necessarily just to the survivor in that situation. I have yet to work on a case where they've done that. And even when the school decides to impose that emergency removal, there's still an opportunity to appeal or have a hearing where the respondent can dispute that finding. So at the end of the day, there's just not a lot of consequences for them.
Becky, if the student doesn't want to go through a live hearing, what can they do?
Yeah. So, unfortunately, if the student specifically is seeking consequences for the perpetrator, which is usually not the case, they just want help themselves, but if they want something to happen to the perpetrator, they have to go through a hearing. That's a due process issue, and But as we mentioned before, the school's required to provide accommodations for survivors, even if they don't want to file a complaint against another student or teacher or professor. So things like also, if the school's a counseling center, they can refer them to there. But the, school students definitely, survivors have rights. They have a right to, bare minimum. I mean, there are bare minimum requirements, which is where often we can come in. If a school isn't giving any kind of accommodation to a student, then we can come in on the student's behalf and say, hey, like, under the law, under federal law, the student has indicated that they are going through gender-based discrimination. And even though they don't want to file a complaint against another student, you are required to give them some kind of accommodation if that's what they're seeking. So yeah, that can look like schedule changes. That can look like more time on tests. That can look like having their dorm changed, or being able to do some of their classes online, which in the wake of COVID has definitely become more of an option than it was 5 years ago. Which is crazy to think about, but that's how long ago it was before COVID. But yeah, so there are things that don't necessarily infringe on anybody else's rights that can help the student a lot in their goals for seeking an education.
So for our last question, Brittany, what happens if Title IX does not apply to the conduct?
So Title IX is only going to apply to conduct that takes place on a school campus or in school-sanctioned environments. So for example, I had a situation where the misconduct occurred when a school faculty member was using a school van to drive the student to the airport. If they're at a debate tournament off campus, if they are at an away football game, those are all areas where it would be covered. Where it's not going to be covered is going to be non-school sanctioned events. So for example, a fraternity party, or in nearby campus student housing, but it's not campus sanctioned housing, things of that nature. However, schools are still going to have a misconduct policy that's largely going to cover a lot of the same things that Title IX will, that can be used to address that through the school procedures. This is going to look completely different for every school. So you're going to want to go look at the student conduct manual, and you're going to want to go look at the school's specific misconduct policies. Those are usually in 2 different sections, specifically to see what the school covers and what their process is going to be. In my experience, schools that do a really good job at taking these issues seriously and trying to support students through these issues will typically use a Title IX-like process and try to conduct it in the exact same way, whether it's Title IX covered misconduct or not, simply just to keep it uniform and to have a robust investigative procedure. Other schools, if it's not required to be covered a certain way under Title IX, again, they have a lot of discretion, and they just kind of do whatever they're going to do. So it's really important that you go look at your school's student conduct policy and then specifically their misconduct disciplinary policy to see exactly what the procedure would be and who you need to talk to if you want to report it.
If you're watching this and you have any additional questions, please leave them in the comments section and we will get back to you shortly. Thank you, Brittany and Becky, for sharing such critical information here today. I'll state this once again for anyone watching. You can apply for legal assistance by calling our main office at 1-800-733-8394 or by visiting www.lonestarlegal.org online. Thank you all for tuning in to The Safe Space.